everyone. I am Catherine Asaro, and I just wanted to thank you all for being here. I know most of you have gotten emails or other sorts of been bothered by me quite a bit this week, so I really appreciate you all being here. If anybody wants to get a drink or some more snacks or anything, you could do it really quickly, and then we're going to go into our first substantive session. And I have the privilege and pleasure of introducing Lesley, Albritton, and Daniel Worrall, who are in the back of the room. If you guys want to come up and get ready. They are both from the Legal Aid Office in Greenville and are instrumental to disaster relief work in the state. Let's see, I can tell you, Lesley went to Kenyon College and then went to Ohio Northern for law school. She's a fellow Ohioan like me. I've had the pleasure of working with her for the past year a lot on different disaster relief activities, and am honored to do that. Daniel is the head of the office, the Legal Aid Office in Greenville, and also not the head, sorry. Supervising attorney, sorry about that. And also doing all kinds of disaster relief work. I cannot say enough about what legal aid does for the state to help meet unmet legal needs. This session is about landlord-tenant. They're also going to be doing one for you later today about FEMA appeals. And I will let them start. And then also I'm hoping that they will talk, if you guys do have any pro bono opportunities, and let you as the audience know about how to plug into that. But we will also be sending information later on too. So thank you very, very much. And also, if anybody's sitting on the side and wants to, there are empty seats up here. If you want to take any of those, you're welcome to. If you don't want to take any of those, please make sure you grab some of the paperwork that is from an empty seat, because it has that CLE information that you need to fill out and leave with us before the end of the day to get your CLE credit, and also has the agenda. All right. I'm going to turn it over to you guys. Thank you.
Good morning, everybody. Thank you all so much for being here. I'm Lesley Albritton. I am the managing attorney, along with Dale Deese, who's over there in the corner, of the Disaster Relief Project at Legal Aid of North Carolina. And I think Daniel does a lot to run the office in Greenville, but he is a supervising attorney, which is a slightly different role with our organization. It means he focuses a lot on substantive work and supervising that, and being a managing attorney means that you're old. So you get to coordinate things. Sorry, Dale, you're not old, but I am. So I'm going to, in just a few minutes, turn the beginning of this program over to Daniel, and he's going to take you through some real nuts and bolts about representing not just private tenants after a disaster. We are going to talk a little bit about the distinctions between that and subsidized housing and the rights of those tenants. This PowerPoint was put together by Roger Cook, who is another supervising attorney at Legal Aid of North Carolina in the Wilmington office. So thank you to Roger for letting us steal his PowerPoint. Roger doesn't know that we stole his PowerPoint. We share a lot at Legal Aid, and that's fine. But I recognize a lot of faces in the room, some of whom are on my team for the Disaster Relief Project, and we're fortunate to have them here today. And hopefully you can talk to some of them at lunchtime about the work that we do and how to volunteer with our organization. I also recognize some of you because I know that you helped us out after Florence and have already volunteered doing this type of work. And I think in a minute we're going to poll the audience and see who's familiar with landlord-tenant and who isn't, and we'll kind of take the pulse of the room so we know where to start. But first I want to talk a little bit about volunteering with Legal Aid. We have about, and Tiandra Miller can correct me if I'm wrong, I think about 215 attorneys right now at Legal Aid of North Carolina, which makes us sound really large, and we are one of the, I think about the fourth largest law firm in North Carolina. However, we are one of the very few firms in this state focused solely on poverty law, and there are far more people in North Carolina who qualify for our services than we can possibly hope to serve. And many of those folks experience a myriad of legal issues in the space of a year. We try to serve them as best we can, but we can't get to anybody, and volunteers certainly help us reach more people. So we need you all, and we love having volunteers, and in my opinion, volunteering is for everybody, including public interest attorneys. I just spent a week in Texas, I will not bore you with the details, volunteering for another public interest law firm on my own time, so that I could get my pro bono hours for the year. That's how much I believe in doing things without getting paid for them. So And we encourage you all to help us out. After a natural disaster, the need in the state just ramps up so much and so quickly. So in the first 6 months, 3 to 6 months after a hurricane or other type of related weather event, we do see a lot of course, FEMA cases, which we'll talk about in a little bit, but also landlord-tenant cases are some of the first types of issues that we see. And many times those clients who are experiencing landlord-tenant problems aren't even back in their homes after having been displaced before they're receiving summary ejectment, which is what in North Carolina the legal term we use to refer to evictions, before they're being served without their knowledge with summary ejectment action. So there's a real need for that type of volunteer service. Now, with that said, I will tell you that we are now obviously over a year out from Florence and over 3 years out from Hurricane Matthew. And we still have many cases in our office, and we still need volunteers for other types of cases. And I think that I know that people have to go back to their regular practices and they have to do their own work so that they can pay the bills. However, we still have a need for volunteers right now. And another thing I will say is that we love people to come in and help us answer the phones and give advice and brief service to clients. However, we hope that these trainings today will help and encourage you all to take on cases for what we call extended service. In other words, have a client handle their case from beginning until the end. So we hope we'll give you the tools and the confidence to do that, because that is what is really helpful to us, is when we can turn a case over to a volunteer and have them be that client's attorney from the beginning of their case to the end. So with that said, I'm going to turn it over to Daniel for a few minutes. And we're just going to kind of jump back and forth. We're pretty casual at Legal Aid, and that's how we present CLEs too. So.
Yeah, this is the only time you'll see me in a tie is here and in court. All right, so my name is Daniel Worrall. I'm a supervising attorney in the Greenville office of Legal Aid. Before that, I was a magistrate, and before that, I was a staff attorney in the Greenville office at Legal Aid. I do tend to speak quickly, so if I go too fast, someone slow me down. I might speak a little slower for this presentation just to be sure. And we're talking about the rights of private and public tenants after a disaster. I'll go through the private stuff and some of the mechanics. Can't hear, sorry. Some of the mechanics of the summary ejectment process in North Carolina, what you can expect, and then what you can see specifically with a disaster, and then go through some of the public housing, Section 8, low-income tax housing, or project-based Section 8. There's a bunch of different titles for it, and actually I'm going to rely a little more on Lesley because she used to specialize in that before she went primarily to disaster relief. There we go. Okay, so this is Chapter 42 is summary ejectment statute. It's the statute that governs everything about a residential lease. And what I'm going to start with is basically, I'm going to poll the audience a little bit. So let's first get out of the way who here works at Legal Aid, because I don't need to talk to you guys about this. So if you saw a hand raised, they're a little shy sometimes. You can talk to pretty much anybody at Legal Aid. Has done two types of cases: domestic violence protection and landlord-tenant. There are two primary areas. So if you ever have a question about it, call up your local Legal Aid office, make an appointment with whoever does housing work, and generally speaking, someone's going to be willing to talk you through it. So that being said, who here has ever actually represented somebody on a landlord-tenant matter, either the landlord or the tenant? Okay, pretty good number. We're going to ignore legal aid attorneys for these questions. So legal aid attorneys, just sit on your hands. Who here has represented them in court, either before a magistrate or before a judge? It's pretty good. Okay. And then who here has had a problem with a landlord, your own landlord? I expect a lot of hands, right? So everybody sort of has that experience of a landlord who's not doing what they're supposed to, who demands rent in an unreasonable manner, who has a lease that is probably has some terms in it that you don't think are necessarily legal, you're probably right, okay? When I was out of law school and I was renting apartments around the Triangle area, my wife would sit there and apologize as I read the lease, and I would just go down the lease and be like, that's not enforceable. That's not enforceable. Okay, we're good. Because a lot of landlords, particularly small landlords, especially out east, in big cities in Raleigh and Greensboro or Place Charlotte, you have large sort of management companies. But a lot of smaller places, rural places out east, where you see a lot of hurricanes, right? You have people who are renting the trailer in the backyard, people who are renting their mother's house, people who have sort of made a living, they've got 4 or 5 houses in town. But they're not professional landlords with a professional management company who knows all of the rules and has a lawyer on retainer. They're pulling a lease from the internet, which probably isn't for North Carolina. And this is an area of law where the state-by-state rules vary widely. If you tried to pull a lease from New York, for instance, you're going to find a lot of tenant protections in there that we do not have here. And every time I have a friend on Facebook who has a problem with their landlord, somebody invariably gets on there and says, well, just withhold your rent. We can do that, so don't worry about it. Withhold your rent until they make the repairs. Not in North Carolina. You can't do that here. So it is an area of law where a lot of people think they know a lot of stuff, and they're thinking about a different state. Or sometimes they're just thinking optimistically, I suppose. So what happens in these situations for a private tenant is that you have a couple of different situations. You have a situation where they were under a mandatory evacuation order. Okay, so they have to leave the house. The house maybe got damaged during the storm, and maybe that damage is minimal, and maybe it's a total loss. And then when it is, FEMA steps in and says, well, we'll give you some money to rent another place. But then what happens after? So a tenant under 4212 can basically tell the landlord that the property was destroyed and they don't want to live there anymore. They do have to pay all the rent accruing prior to the destruction, right? So whenever the hurricane or other natural disaster hit. But the lease provision controls. Now, I actually don't see a lot of hurricane-related lease provisions. And obviously, they still have to be conscionable. But have you seen any lease provisions that specifically refer to disaster? I haven't, no. So that's not a thing we see a lot. But as we get more disasters, it may be something that happens. Landlords can tend to be a little tricky with the provisions. And if you have a 4-page lease and you sign it, you're deemed to have read all of it and understood all of it. And the chances are that you didn't read any of it and you wouldn't understand it if you did. Okay, so again, unless the lease provision states otherwise, there's a specific amount of time you have to give your landlord, or the landlord has to give the tenant, before they can terminate the lease. So as it says, 1 week prior to the end of the month, if it's a month-to-month periodic tenancy, 2 days prior if it's week-to-week, 30 days prior if it's year-to-year. We don't really see year-to-year leases. Generally, most landlords will do a year-long lease that's paid monthly, and then once that ends, it just automatically turns over to a month-to-month tenancy. I will say that since landlords are pulling off these leases from the internet, a lot of them do contain a notice provision of 30 days, which is a standard in some other states. And the lease provision controls. This is one time when it's good for us that the lease provision controls, because a lot of times people ignore that. Although the flip side, if the tenant wants to get out of it, it still applies. So in this particular context, it's not good. But normally, it's the landlord trying to terminate the lease from the tenant. Warranty rights. So chapter 42, like I said, is the residential lease section. 4242 is the most important part of that, particularly as it concerns a disaster. So chapter 42, section 42, is the duties of the landlord to provide a habitable apartment, right? If I'm providing you a place and you can't live there because it's been destroyed by a hurricane, or it's mold infested after the hurricane and you tried to repair things, or it doesn't have a roof, that's the section as a lawyer that you want to look at. What did the landlord have to do? What are the notice provisions that the tenant might have? They should always put maintenance request in writing so that we have a written record, and often some of these requests have to be in writing or they're not valid. So then we have the duty to pay, mutually dependent with owner's compliance. That's where we lose that right to withhold, right? So in North Carolina, if there's no roof, you can't just decide to pay no rent, which is usually, sometimes you occasionally will find somebody who says, there's this problem, I can't use the bathroom because the toilet's broken, so I'm gonna pay $50 less in my lease for that small error. I very rarely find that. It's usually an all or nothing proposition, right? Either there's a problem with the place, I'm paying no rent until it's fixed, or I'll pay all of the rent like I'm supposed to. In North Carolina, there is no self-help right to rent abatement. You have to get a court order that allows for you to pay a lower amount of rent. Unless, as does sometimes happen after a disaster, there's an agreement. You do want that agreement to be in writing and documented as a lawyer or as a tenant. So they can agree, and we certainly have seen landlords who said, hey, until this place gets fixed, I'm not going to charge you any rent for this place, or until I can fix that bedroom problem, I'm not going to pay me half the rent, or we'll work it out. That does happen a lot, but again, it's best if it's in writing, because if it's not in writing, then when they go to court and show the lease over and our client says, well, we had an agreement, well, prove it, right? As a magistrate, I didn't do a lot of landlord-tenant stuff, but I can tell you, both from my experience as a magistrate and in my experience as an attorney, the landlords are in small claims court every day, right? They're there. We have magistrate's court in Pitt County 3 times a week, Monday, Tuesday, Wednesday. The big management companies are there every day. Even the small landlords are there pretty frequently. The magistrates know and trust the landlords because they see them every day. And most of the time they come in, it's because somebody didn't pay their rent. So it's hard to overcome that relationship. You need proof. You can't just go in there on the say-so of your client because they have a history of trusting these landlords. And that's just, it's sort of like they're like the cops of the small claims court, right? The judge sees the cop every day in a criminal context and has developed a better relationship with them than they have with a person they've never seen before. Under 4244C, like I said, there's no right to withhold rent, but you can go to court for judicial determination on these sorts of things. Generally, if you do that, it is best to not be behind on rent when you do it, because otherwise it seems like you're trying to use the courts to sort of repair a past misdeed, and nobody's going to like seeing that. So it's best to be current on rent, even if they get current on rent right before they file, to do that. And we'll go over, this is the most difficult part for me in the context of disaster is this: they have to restore the premises to fit condition within a reasonable time. So after a disaster, as many of you probably saw doing volunteer work or just living around, nobody's there to make repairs. Half the people who are there are scam artists, Insurance companies are fighting back, particularly in large things like apartment complexes where the insurance is going to run into the millions of dollars. Okay. And so reasonable time is, it's based on the totality of the circumstances. There's no statutory definition that says within 7 days, with a few exceptions like how quickly you have to repair smoke alarms, for instance. But in the context of this, a reasonable time is a reasonable time. What efforts have they been making? There's a complex down in Wilmington that still has not allowed people back in after Hurricane Florence. And they're still claiming that they need time to make repairs. And it's 13 months, 14 months after? Thanks. There's a good argument to say that their amount of time has not been reasonable and they haven't been operating quickly, but certainly a place that's been out 6 months, right? Maybe that's different. And here's one of the harder parts about this as well. If FEMA doesn't step in to assist with rental assistance, and we'll talk more about FEMA in an hour or two, the landlord doesn't have a duty to pay for other housing, right? So a lot of people think that, that if the landlord can't provide me with a place, with my place, they need to provide me with something else. It's not the law. They can't charge you rent for a place that's unlivable, but they don't have to provide you a place. And a lot of times you have however many, 200,000 people or so in Wilmington, and you have half the apartment complexes destroyed. You're not going to find a place in Wilmington. They may have to go further away, particularly if they can't get FEMA assistance. Like I said, we'll talk about that more. You can get rental assistance from FEMA, which is a bear in and of itself. So that's also problematic. Now, can't remember where we are. Right, just went over that. Right, this is, so there's two sort of ways to attack these cases. One is going in and doing everything you're supposed to right away, that sort of thing. But another one is that if the owner refuses to make adequate and full repairs and then demands rent, that you can sue affirmatively for habitability. And if they're doing this in some sort of, they're saying the place is fine, we can clearly demonstrate it's not fine, and when they demand full rent, they're saying it's fine, right? That is in and of itself a statement that this place has had no lack of value. There's no diminution of value in this place. You still have to pay me every cent, whether or not you have access to the second bedroom or a roof, or your floorboards are rotting through, which is the case in a lot of mobile homes. That is an unfair and deceptive trade practice. There's case law which says, yes, being a landlord in North Carolina is applicable to the statute, to Chapter 75. And one of the nice things about this is that we call it UDAP usually, a UDAP claim. The unfair and deceptive trade practices allows for treble damages for your client, and sometimes you can change your pro bono case into a fee-generating case because you can also get attorney's fees. And in fact, the statute says, shall get attorney's fees. So it is a powerful statute if they're doing that. And a lot of landlords did this sort of thing. Right. So the owner's not responsible for tenant property losses caused by disaster. This is another big one that comes up. A lot of leases now state in the lease that the owner or the landlord encourages renter's insurance. If a natural disaster comes in, if it's not through the fault of the landlord, then there's no duty on the landlord's part to replace beds, to replace clothes, toys, TVs, unless they were not following their duties, right? So if we can prove that, for instance, as has happened in some of our cases, there was a rotting tree that the landlord had knowledge of and was informed, hey, this tree's going to fall on my house the next time there's a hurricane. And then, lo and behold, if a hurricane comes through and that rotting tree hits your house, then they might be liable for the personal property damages. But that's almost certainly going to take a lawsuit, right? They're not going to just pony up on that. But generally speaking, there is no duty on the landlord's part to pay for personal property loss. You should always encourage people to get renter's insurance. Renter's insurance is actually really cheap. A lot of people can afford it. We'll see how long it stays cheap, I suppose, as more things go in and they pay out more claims. But at the moment, anyway, it's really cheap. And it's something we should certainly consider. Okay, so within the context of disaster, am I doing on time? Okay. What we saw was, so let me just run through how it's supposed to work really quick. What's supposed to happen is there's a default on the lease, just like any other contract. Usually, it's failure to pay rent. But sometimes it's property abandonment. It could be that they broke a condition of the apartment complex, like they got into a fight, they brought drugs onto the property, their kid brought drugs onto the property, or something along those lines. Their kids run around and lit a fire in another apartment that's happened. So it could be another type of lease, but generally it's non-payment of rent, particularly if you are evacuating, right? You're preparing, you have to get a hotel room somewhere else, you have to pay your brother-in-law $100 to use the garage, whatever it is. And FEMA doesn't reimburse those costs. They don't reimburse evacuation costs. So if you're strapped for cash and you're paycheck to paycheck, that money has to come from somewhere, and a lot of times it comes from the place you're not gonna be during the hurricane, so it comes from your rent money. So what's supposed to happen is the landlord makes a demand for rent. The demand can be in the lease itself, essentially. It says that it's sort of a self-demanding lease. And then after 10 days, if they don't receive the money, they can start a summary ejectment claim. Summary ejectment claims go at a lightning speed. Within the time it takes you to answer a normal complaint, your client will be out of the house and will have lost any right to appeal, right? It's gonna be over within 30 days. Really, from the time they fail to pay rent, that could be true. So it's way faster. This is one of the reasons why we encourage you to take cases for extended service, take on clients, because if you answer some landlord-tenant questions for a client, and then they need to be passed back to a legal aid attorney or another attorney for service, the time it takes us to re-catch up with everything is valuable time. That would be much easier for us if you went to court in that time instead of having us re-catch back up with what's going on and reformulate any legal theories and make a connection with the client again and gain their trust. So especially in the context of landlord-tenant, we really encourage you to take on the client as a client and not as a question. So the 10 days passes, they get into court. They're usually in court within 7 days, if not 4. And there are specific rules about why and how it's so much shorter. Like these are written into the rules that they don't have to do anything really, they just get into court really quickly. They get into court, summary judgment is usually found. Clients often do not show up. There are reasons for that I'll get into in a second. So that happens, they have a 10-day appeal period. If they appeal, they also have to pay a rent bond of the amount of rent. And there are calculations about exactly how much that rent bond is that have to do with when the summary ejectment was entered. But they have to pay rent, so if they don't have that money, then they can proceed on their claim without living in the apartment. And usually, after the 10 days are up, 3-4 days, depending on your county and how quickly the sheriff moves, they can be locked out. The lockout occurs with the sheriff. They usually post something like a day before that says, hey, I'm coming back 9 o'clock in the morning on this date, and then lock the door. They don't actually lock the door, somebody else does, but the sheriff stands there while they do it. In the case of mobile homes, they sort of rope the house off and lock it sometimes. And that's it. I mean, that's your client's out. They have 7 days after that to pick up their stuff if they haven't already. Always, always, always recommend that your clients take all of their stuff when they leave, and anything they leave behind they take pictures of. They should be taking pictures anyway of the condition of the house to get their security deposit back, although they may not get that either. So it is a lightning fast process. But one of the things that North Carolina law does not allow is, just like it doesn't allow for self-help rent abatement, it also doesn't allow for self-help eviction. The landlord is not allowed to go there and say, you didn't pay me rent, so I changed the locks. After a disaster that happens, I mean, it always happens, but especially after a disaster that happens a lot. And then they claim it's for safety, right? They say, it's dangerous in there, I have liability issues, I don't want you to do that, you can't go back in the house. That's not legal. Even if it's perfectly reasonable, it's not legal. Unless that house has been condemned, then they can't do that. Particularly in the case of people who evacuated with the few things that they could have, need to get back in there and see what's still there. They need to get back in there to take pictures of their personal property so that they can provide evidence to FEMA to get recovery for personal property. They need to get back in there because they didn't bring their lease with them when they left. So we don't have any evidence for what lease conditions might have been violated. There's a lot of reasons that they might need to get back in there, but the primary one is it's illegal to keep them out, right? Until a judge says so and then the sheriff comes out. They don't have any right to do that. They also may not seize the tenant's personal property just because that stuff was in there. Just because they think that they're owed money. They don't have any right to the personal property. It's just like a car repossession. You can't steal the car seat that's in the back of the car when you repossess the car. You have to give that back. It's not yours. Now, a lot of times the tenant won't return and retrieve their belongings. And there are rules surrounding what you do with that and how long you have to wait and where it can go that I'm not going to get into right now. But you can certainly feel free to ask me questions about it. You have a question?
How do you think the law works out in the situation where, say there's damage to the roof, the landlord feels they need to get in to repair, the tenant's belongings are in the way, the tenant has evacuated? What do you think the law says?
Right, so the question was, what happens if there are needed repairs? The landlord deems that there are needed repairs, but there are belongings in the way of those repairs. And
Especially like because you're taking a
Sure.
floorboards.
yeah, so it's essentially a Bailey argument. They can do what they need to for repair issues, but they're going to be liable for any damage. So if they go in and they decide instead of moving the couch, they're just going to chuck it in the yard, then they're going to be responsible for the couch. But if they move the couch into storage, it's kept in temperature control. It's not damaged in any way. If you are a landlord, you should take a picture of its condition before you move it, particularly after a hurricane. It's probably going to be damaged already. But if they don't do those things and then it comes back damaged, you have a potential claim for that. But landlords are allowed maintenance rights. They generally have a duty to inform that they're coming in for maintenance, but they're allowed to come in. And we have a lot of clients. There are clients with certain disabilities as well who do not want people coming into their house even to do repairs. And that's a big problem. And you get things like threats against the maintenance people on the breach, as a breach of lease. You do need to counsel your clients that they have not only do they have a right to repair, they have a duty to repair. And they're allowed to take reasonable steps to do that repair, as long as they're giving notice of their intent and following the lease conditions when it comes to that. Yes.
A question procedurally.
Yeah.
Normally, I was a woman, and we had a lot of hurricane issues.
Yeah.
Someone would call and say, we have damage to a rental house that we live in. We didn't pay money because we were out during the evacuation. They moved for some reason, rejected it. Procedurally, what should you do at that point if they've already moved for some rejection and you think there's repairs need to be done
Okay, so this is a procedural question and a very common case in any part of the state where there's a summary ejectment case and an argument that during that time the landlord did not comply with their duties to maintain the property. So essentially it's the case where either the person didn't pay rent because they didn't have money, or where they didn't pay rent because they were doing a self-help rent abatement to try and force the repairs to be done. And how do we attack that procedurally? So yeah, what you can do in that case is you can counterclaim for a rent abatement claim and be prepared to pay whatever is left. So a nice thing about landlord-tenant law is essentially that if they can pay rent before that judgment is done, plus court costs, that they can avoid the summary ejectment if it's only on the basis of money. It's only on there's no other breaches, no other lease conditions that were breached. They can pay the money and escape the summary ejectment. A lot of magistrates think that they have to do it within 10 days after the judgment. That's not true. They pretty much have to do it before the judgment. But so you can still counterclaim, and you can counterclaim pretty much up to the start of the trial, because it is so summary. You don't have to file an answer, or you can hand over an answer as you go. And so you can file for counterclaims for rent abatement, but if it doesn't bring the rent down to zero, like if it doesn't bring the back owed rent down to zero, then unless you pay the rent, you're going to be subject to summary ejectment anyway. Yeah, Lesley's going to add something.
So I think I also heard in your question or in your scenario that maybe your folks did not pay rent because they were in fact under a mandatory evacuation and were in town to pay their next month's rent. So just as a practical matter, how would I as an attorney handle that situation? That's a really good opportunity to sort of advocate for your client outside of court and be the person who calls the landlord and says, especially if your client has the rent money, which is always the best case scenario, but the place is trash, always the best case scenario, rarely the reality. Obviously, I mean, they're probably staying in a hotel somewhere, so maybe they spent their rent money on something else. But if they can find a way to get it, and I will also tell you there are a lot of organizations right after a disaster who are on the ground and willing to help people come up with rent money and things like that, so take advantage of that. We have lists, thanks to our wonderful paralegals and social workers in our project, of those resources that we update regularly. So if you're ever looking for somebody to help you with something like that, just some cash on hand, give us a call. That's when I would get on the horn to the landlord and say, look, you know that your folks were not actually living there during that month because they couldn't. They were told to get out and you didn't want them there, and also the place is trash. So let's work something out here where you dismiss this summary ejectment action. You know, we'll come to an agreement about what the value of this place is. If they hire an attorney to represent them, that's always fabulous too, because dealing with a mom and pop landlord is so much harder than dealing with their attorney. So, but ahead of court, I would be on the phone in that scenario trying to work something out. And I will offer you a note of hope as well. These magistrates who are hearing these cases right after a hurricane or a, wildfire or whatever, these are people in their communities, and they tend to be a lot more sympathetic in that scenario when they're confronted with day after day of people being evicted in the worst of circumstances than they might be on a normal day in small claims court. So take it to heart that, you can share that with the landlord. Hey, I don't think you're gonna, even if you win at the magistrate's level, I'm gonna appeal this and we're gonna take it to district court, and these judges and these magistrates, they're gonna see what you're doing, so let's work something out.
Yeah, I couldn't agree more. As a practical tip, it is always best to call the landlord if you can and try and work something out. That's how we get most of our clients to stay in the house. There are really bad landlords out there, but a lot of times there are really good ones too, especially some of these mom and pop ones are really willing to work with clients. They know them, they're friends sometimes, and they're sort of at their wits' end. So I certainly encourage anytime you have a case like this to try and negotiate before court, particularly if you have any money that you can hand over in good faith. It doesn't have to be the full amount of rent. Sometimes it can be something worked out if you have any money for them, or if you can get any money from them from some of these resources. And hopefully the next time a hurricane hits, not that a hurricane will ever hit again, but most of the charities have been aware of the fact that no one knew about some of these resources when they started, and they're trying very hard to make sure that information about where you can get resources like rent money, security deposits for new places, and things like that are available to people much sooner, and in a much more coordinated fashion this time around. I want to make sure that we get to some public housing. So a couple things to note. Your client may never know that there was a summary ejectment proceeding. So we allow for something called service by posting, only in this particular context, where they just stick a thing on the door that says, hey, you got to show up in small claims court in 4 days. And your client's evacuated. They're never going to see it. Never, ever. And they don't send them one in the mail, and they don't serve it by a sheriff. If they have the ability to have someone who looks at the house, someone who's still in the community who can tell them if that shows up on their door, that's great. The key thing about that is that if that's how service was done, no money judgment can be entered because they don't have personal jurisdiction. Essentially, they get in rem jurisdiction over the apartment. They don't have personal jurisdiction over the person, so they can't get a money judgment. They can only get the summary ejectment. If you do happen to go to small claims court at some point, you're going to see a whole bunch of cases where no one shows up on the other side for various reasons. Because sometimes you may actually say, if you show up at court, you're going to get a money judgment. If you don't show up at court, I would never advocate to say, tell your client not to go to court, but make sure they're aware of the law. Let's see here. I think that's all the practical tips. Did I miss one? Yeah, and then you can start talking about public tenancies.
Oh, good. We don't have a lot of time. That's good. You won't have to listen to me for too long. A note on posting. I was actually going to talk about that for a minute anyway. I alluded to this in my little introduction spiel. A lot of times after a natural disaster, you will see opportunistic landlords getting rid of tenants by using that means of service. So you'll have clients who are under an evacuation order. So they were not in their home. They were unable to get back for a variety of reasons. If you see a situation where a client comes to you and says, I'm being locked out of my apartment, I didn't know that I was even evicted. How can my landlord do this? The sheriff came out and with a writ of execution and says that I got to get out, got to get my stuff out. And they tell you that they never received notice or any kind of service after a natural disaster. In that scenario, it's probably true. So the things you want to find out from a client in that situation are, were you under a mandatory evacuation? Did your landlord know that you weren't there? Did you continue to communicate with your landlord about when you were going to return, when you could get back in? We've seen things like landlords telling people not to come back because the house was, in no condition to live in, while simultaneously sending them, service by certified mail at the destroyed residence and then, posting on the door where they knew the tenant wasn't living. In that circumstance, there are things you can do for that client, and a Rule 60 motion to set aside that summary ejectment is certainly appropriate and many times is going to be granted. We've had some success on that outside of natural disaster situations, so I would encourage folks to take a really hard look at service issues after a natural disaster. It's not just here in North Carolina. If you talk to folks in Florida and Texas who do this work, you will hear that this is just something that happens constantly with renters. I love the title that was given to our program, Preventing Homelessness After a Natural Disaster. That sounds really ambitious, but hopefully true. If you look at, and we don't have slides in our presentation about this, but I encourage you to get onto the North Carolina Housing Coalition's website and take a look at some of their wonderful information about renters in North Carolina. If you look at the counties we see repeated in the sand hills and along the coast that are repeatedly struck by hurricanes in this state, and you overlay that with maps of cost burdens for renters and lack of affordable housing, you will see that these counties are the very same counties that get hit repeatedly. So it really is, when you take a landlord-tenant case, such important work. And couple that with the fact that there is so much research being done to show that tenants are the people who recover the least from a natural disaster and the slowest from a natural disaster. So that really is the goal when you take a landlord-tenant case in this scenario, is to help people stay in the housing that they have while we do some work at the state level to try and beef up the affordable housing in the state of North Carolina, which is really important work too. All right, so I don't think we don't have any slides really on subsidized housing, but in the little bit of time that we have left, and I'm going to leave 5 minutes for questions, I promise, but I did want to talk about sort of the distinctions between subsidized housing and private landlord-tenant, especially in the scenario of a natural disaster, because the good news for subsidized tenants is that they always have, well, I won't say always, it depends on the type of subsidized housing, and I don't have time to get into all the distinctions with y'all, but they usually have far greater protections than people in just a private landlord-tenant situation. Now, I will say, though, after a natural disaster, the statutes and leases are not suspended. So even if you have a person in a private landlord-tenant situation, make sure that you are looking at the statutes and looking at the lease, and that the landlords are following those. So let me get to some notes here so I'm going to talk to you all a little bit about the scenarios that we actually saw after Florence and some of the things that we saw happening in subsidized housing. So there are several different kinds of subsidized housing that are found across the state of North Carolina. A lot of the housing that we have is what we refer to in the legal aid world as LIHTC, or low income taxpayer credit housing. That is the guidelines for LIHTC housing are found in the tax code, believe it or not. It's subsidized by IRS, so it's sort of a different animal. However, there tend to be, even though there aren't great statutory protections for folks who are in LIHTC housing, there tends to be a lot in those folks' leases that prevent them from just being put out without some kind of notice. Landlords for LIHTC housing do not have to necessarily provide a certain amount of notice to clients before lease termination. However, frequently they'll put it in their lease. So the first thing you want to do if you know your client has some kind of subsidy, and most of the time, clients are not going to be able to tell you what their subsidy is. So if you get somebody on the phone and you say, well, what kind of subsidized housing are you in? They very well might not know. So you just want to find out the name of the project that they're in, the name of, and you can look it up online from there and sort of figure out what the subsidy is. Is it public housing? Is it LIHTC? Is it project-based Section 8? If you can't find an apartment complex online, or you find out that they're renting from somebody who just has one house, or they're in a small complex, that's usually a cue that they have a Section 8 voucher, which is also a very different animal. But you can usually get to the bottom of what type of housing your client is in, and from there you can start to look at what their options are and what the landlord's duty is. One of the big things we saw after Florence is HUD subsidized housing, where the landlords, and this is different, this is not public housing, where tenants just have a lot of protections, including a duty to rehouse those folks while repairs are being made. But this is things like project-based Section 8 housing, where the landlord is receiving a direct subsidy from housing and urban development. And so Housing and Urban Development has a lot of say in what goes on in those properties. But nevertheless, particularly out in the Wilmington area, where there's a lot of affordable housing, or there was a lot of affordable housing downtown by the water. I'm not suspicious, but if I was, I would think that Florence came in, it was maybe a light bulb went off in some of these project managers' heads that, oh, well, this is a good opportunity to turn this into some better real estate. We could charge more money for it. If these folks have a HUD subsidy, however, that goes to their project, they're not allowed to just say on their own, hey, this property is so badly damaged that you can't live here. Everybody, sound the alarm, get out now. You've got, in the cases we saw, it was usually 72 hours notice to pick up your stuff, get out of here, you know, you shouldn't be here. It's a health hazard. They were telling people within 24 hours of Florence hitting that there was too much mold in their apartment for them to live in. I am not a mold expert, but I know, because of my own home sometimes, that mold does not grow within 24 hours. You have to let it sit for a while, folks. So you know, they're just using this opportunity, or they really are afraid that something's going to happen and someone's going to get injured. I'll give them the benefit of the doubt. Or they've got insurance and they want their adjusters to be able to get in there and take a look at the place without tenants running around. But they're using the storm as an opportunity to get people out. Not allowed to do that if you have a HUD subsidy. The place either has to be condemned, or Housing and Urban Development conducts its own inspections, and they don't do it all that quickly because there are a few of them, and there were a lot of damaged properties after Matthew and then Florence hit. They will come in and inspect the properties and decide whether tenants need to leave. So a lot of the work we did after Florence was putting that on Housing and Urban Development's radar so that they could come in and tell these landlords, hey, you can't just be throwing people out. So in that circumstance, look at the client's lease and look at the guidelines, whatever guidelines apply, CFR parts or the federal code, about what is required for notice. Sometimes tenants' leases can be terminated. However, they're entitled to a certain amount of notice. So that is something to really look out for in those kind of cases. Another thing that we saw was properties that were legitimately destroyed. We had a case out in Carteret County where the property was actually condemned by the health department. So in that circumstance, folks probably have to go. And also, if we take that to court, we're probably not going to win that battle because, the inspector is a neutral person. Why would he just kick people out? It's not like the landlord did it themselves. But a lot of those clients had Section 8 vouchers. So their landlord and the local housing authority really did do a good job of finding them other places to stay and of initially preserving their Section 8 vouchers. However, after about 3 months, the local housing authority got bored and got tired of letting these people kind of hang out on other folks' couches and started sending them threatening letters about, you better find a permanent place or we're going to yank your vouchers. Not okay. And this was an elderly complex, so these folks were, they'd build their lives in this little area of Carteret County, and their doctors were there, and their friends were there, and all the resources, their senior center that they went to was there. It's not that easy just to pick up and leave to another county. So we were able to talk to that housing authority and ultimately get Housing and Urban Development to talk to them and tell them that, there are guidelines you have to follow. You are allowed to extend people's vouchers pretty much indefinitely after a natural disaster, and y'all ought to be following our rules. So those are some things to look out for when you encounter a client who tells you, part of my rent is being paid by somebody else, because there are better protections than just what's in our North Carolina statutes and then what's in their lease. And unfortunately, does anybody have any questions? Uh-huh.
Some good skills for this. I volunteer at resource centers and I'm happy to do it. And I know you asked repeatedly that you take on extended representation, which I would be willing to do if I were competent, which I am not. So these days like today are great, but is there any possibility of getting a mentor when the next hurricane hits, whether that's a legal aid person or a staff or an attorney in the state who knows more about this very well than I am?
So that's a really excellent question. First of all, I think y'all probably are competent to handle a landlord-tenant case. I mean, I spent a week doing asylum law. I do not do asylum law. So, you can do more than you think you can, I swear. But I think that's an excellent idea. She asked, for folks who couldn't hear, whether or not, and I understand this completely, you don't want to take on a case and not do what you're supposed to do for the client and feel like you're not doing a good job. So can we have mentors? Yes. I mean, I think if it's something where you feel like you need the support of a local legal aid attorney for that first landlord-tenant case, that's something that we would set up. And it would have to, there are private attorneys who do landlord-tenant, but for the most part, it's us, especially with the subsidized cases. But I would love to teach people how to tackle subsidized housing. I mean, I think it is such an important piece of what we do and such an important way of stabilizing families. So happy to do it. I would say if you want to volunteer, you would call. So the way we do our intake for volunteers is you can sign up online. And then we actually have, I don't think we have anybody from our central intake unit from our pro bono team here. But when we take a volunteer and we assign them a case, we do actually assign them to an attorney at our central intake unit to guide them through the process and be their point person. Has anybody in the room done that and want to talk about it?
I have.
Okay.
So with all due respect, in the days after hurricane, it just, resources were thin.
Yes.
Weren't available. And I couldn't get what I needed to feel confident.
Okay, so that was actually going to be my caveat. I know that in Florence we ran things a little differently because, as you said, we had a lot of cases. But our the typical way we do it is that we provide somebody with a support person. That said, you are always welcome to email me for a disaster case. Please not for like a typical consumer case because I probably can't help you, but you're always welcome. Email Daniel for that. You're always welcome to email me or to email someone on our pro bono team and let them know I feel like I need to be partnered with somebody from the local office to walk me through that. And in the Wilmington area, we have several attorneys on that staff who do landlord-tenant cases, and I'm sure they would be happy to go to court with you. Walk you through. I've done that with domestic violence cases and volunteers and walk them through the process. So absolutely. Yeah. Oh, 3 minutes. Okay. One thing I didn't get to was our price gouging statute. So before I take another question, I knew there was something else that I was missing. So North Carolina does have a price gouging statute. However, it is very time limited, unfortunately. It is, and so it's triggered by the declaration of a state of emergency. You know, when the governor declares a state of emergency, really we're doing that so that we can get some resources flowing and some protections in place for consumers and tenants. But it's only 45 days at the outset, and then it can be extended for another 45 days. And somebody correct me if I'm wrong, that's it, right? So, but if you see after a natural disaster a landlord who is trying to raise the rent on tenants, and we do see that, that is a great thing to refer to the Attorney General's office because it's not allowed, at least within that first 45 to 90 day period, if the price gouging statute is in effect. And that did happen, and it also happened with people who were renting from hotels using their FEMA temporary housing assistance. So, you know, keep that on your radar as something to look out for. Has the landlord tried to use this as an opportunity to say, your rent was $400, now it's $600? Any other questions? I'm so sorry that I didn't have time to go over more with subsidized housing. I know that I sped through that. The best thing to know as a volunteer about subsidized housing is that if you take a case and you ask questions about how your rent is being paid and you determine that the client has a subsidy of some kind, that's when you look online for the guidelines. We have great resources about subsidized housing that we can provide to you and walk you through that. But just those are the people who need our help the most, but they're also usually the folks with the most protections and a property interest in that tenancy. So those are great cases to take on because usually we can be successful because landlords tend to mess up on a procedural level with those folks. Anything else? All right, well, thank you all so much. We will be back to tell you all about the wonderful world of FEMA.